We are live, sir.
Greetings to all those present. My name is Ankit Malhotra. I am a student of the law school and the co-founder and president of the Jhadav Society of International Law. It is a privilege and an honor to be in the company of such a constellation of stars in the galaxy which overlooks the horizon of international law. I welcome the Vice Chancellor and the Dean of the Law School, Professor Dr. C. Kumar, to give the welcome address.
Thank you very much, Ankit. I would like to extend a warm welcome to Mr. Harish Salve, Senior Advocate, Supreme Court of India, somebody who I grew up looking up to and has been a great source of inspiration. I had the privilege to invite him to the Campus Law Center Faculty of Law, Delhi University in the year 1995, when I was a student between 94 and 97. And I still very vividly remember the day when I met him at his home, and we traveled together to law faculty, and he gave one of the most inspiring lectures on constitutional law and the importance of protecting the rule of law. That in many ways laid the foundations for many of us who ended up being committed to law. Of course, that journey took me to different parts of the world, but I'm very, very delighted that today we are having with us, although not physically, Mr. Harish Salve to be part of this absolutely exciting event. I'm grateful to the Jhadav Society of International Law and the Center for the Study of United Nations, both Professor Vasilin Popovsky as well as Ankit for putting these together. I'm particularly grateful to my colleague and former ambassador to the Netherlands, Professor Ambassador Rajamony, who is now a professor of diplomatic practice at Jhadav Global Law School. As all of us know, Mr. Harish Salve was the counsel for India in the Kulbhushan Jhadav case. This is a case in which India's rights under the Vienna Convention on Consular Relations 1963 have been violated by the actions of Pakistan. India's victory in obtaining provisional measures by the order of the court dated 18th May 2017, which stayed the execution of Mr. Yadav, is also a victory of international law, of due and fair process of the principles of natural justice, and indeed of the rule of law. It is also a testimony that India's contentions, which were motivated by the many constitutional guarantees India provides under its constitution, but also beyond that, were upheld by the International Court of Justice. And this has also upheld the principles of international law that many of us are deeply committed to. I also want to mention that for all the students who are watching this, it's an extraordinary journey that Mr. Salve has had in his own career. And this is something which you should all keep in mind. Mr. Salve is somebody who straddles across different areas of law. He's been an authority in taxation law. He has done significant cases in corporate law. And of course, he's a very distinguished constitutional lawyer. And through this case and more, he has also established his credentials as an international lawyer. And in many ways, because of the substantive grounding in the principles of law and jurisprudence that Mr. Salve had, and because of his voracious reading and understanding of comparative law, international law, transnational law, as well as Indian constitutional law, he was able to draw upon those principles and constitutional values to be able to argue before the International Court of Justice with such dexterity and conviction. We couldn't have had a more inspiring lawyer to be with us today to talk about the case and indeed to reflect about what it means for the future of international law and also the future of international legal practice. With those words, I would like to extend a warm welcome to Mr. Harish Salve. I can only hope that at some point of time in the near future, we will be able to host him physically on campus at OP Jhadav Global University, as he is somebody who inspired me so much in the early years of my own academic journey, which began in Delhi University and went through Oxford and Harvard and other places. So I'm so personally delighted to see him here, and thank you very much. All right, if Ankit seems to have some difficulties, so I'm now going to invite Ambassador Professor Rajamony, Professor of Diplomatic Practice at Jhadav Global Law School, to introduce the speaker as well as the topic of today's lecture.
Thank you so much, Vice Chancellor Rajkumar, and good evening, Mr. Harish Salve. Good evening, all viewers. It's my great privilege and honor to welcome to this discussion on behalf of the O.P. Jindal Global University, Mr. Harish Salve, and to introduce him as well as the topic of today's discussion. Mr. Salve, as has already been mentioned by the Vice Chancellor, is one of India's most eminent lawyers, having seen him in action in the International Court of Justice, as well as the Permanent Court of Arbitration. I have no hesitation in saying that he is one of the world's most eminent lawyers, and he also has a roaring practice, if I can call that, in the United Kingdom's bar. He was designated a Queen's Counsel in 2020. Mr. Salve was Solicitor General of India from 1999 to 2002. He specializes in arbitration, especially international commercial arbitration, as well as litigation right now in terms of his international practice. But in India, there is probably no important case where he has not been sought after. He has been counsel to the central government in many important cases. He has been counsel to many state governments. He has also been sought after by the leading corporates of this country, as well as leading multinational corporations in the world for their cases in international tribunals. Mr. Salve started his career as a chartered accountant, but then went on to practice law, including under very eminent people. He has been junior counsel with Nani Balkiwala, with Mr. Suli Sorabji, all of whom are legends in the field of law within India. Mr. Salve's interests straddle public international law, human rights, civil fraud, and a huge variety of cases. He belongs to a very illustrious tradition. His father was also a chartered accountant. He was a senior political leader, a minister in the government in India. His grandfather was a criminal lawyer. His great-grandfather was a judge. So law runs deep within the family. Mr. Salve was awarded in 2015 the Padma Bhushan by the government of India in recognition of his contributions to his nation. And let me just mention that his reputation and his demand is so high. One of the first questions which came up when the Jhadav case came up was, what is Mr. Salve going to charge for this case, which is so big and so prestigious? And may I say that as a wonderful gesture to this nation, as an act of service, he charged ₹1 as his fee for the Jhadav case. I will go on to briefly talk about the topic. As the Vice Chancellor has said, we are going to discuss the Jhadav case and the lessons that we can draw from the case for international law. The Jhadav case was a landmark in every sense of the word. It strongly, the judgment of the court, with only the Pakistani judge dissenting, strongly upheld the right to consular access under the Vienna Convention on Consular Relations. In fact, some of the judges who appended separate opinions went on to say that perhaps the International Court did not go far enough. It should have used even stronger language to declare the right to consular access as a human right and not just as a treaty right, and also as an integral element of due process of the right to fair trial. I'm sure Mr. Salve will talk to us about that. On jurisdiction, the court was unanimous in saying that India had jurisdiction, and that also establishes a very clear point for the future. Provisional measures, wherein the execution order passed by a military court in Pakistan was stayed by the International Court of Justice, happened within 10 days of India filing an application. On the 7th day, I think, or the 8th day, we were already called to appear before the court. Mr. Salve appeared. So once again, in provisional measures, a precedent has been set for the International Court of Justice to act very quickly. Review and reconsideration, effective review and reconsideration was the order passed by the court. It follows on certain precedents in the Avina case and the Lagrand case. But however, there has been opinions expressed that perhaps the court could have gone even further in tailor-making a specific remedy in this case, especially in view of the fact that Jhadav was sentenced by a military court and not a civilian court, as in this examples. The Pakistanis used the argument of a bilateral consular agreement to try and oppose our application. The court completely rejected that and said that the agreement can only amplify, not reduce the rights in the Vienna Convention. And finally, unfortunately, Jhadav still continues in jail today in Pakistan. The Pakistanis have not released him, even though they argue in public that they have implemented the International Court of Justice. Since the judgment, the Pakistani government passed an ordinance initially, and then Parliament passed the legislation, a specific legislation to try and partially at least implement the judgment, providing for review and reconsideration. How adequate is that? That is also something we would love to hear Mr. Salve's views, as well as the fact that the Islamabad High Court, the case is pending before the Islamabad High Court, and Islamabad High Court has been calling the Indian High Commission to appear before it, but so far the Indian High Commission has refused to do so. With these few comments, I invite Mr. Salve to deliver his remarks on the topic. And let me just conclude saying that it was a great pleasure and a learning experience to work with him, to spend time with him and be part of his team during the Jhadav case. Thank you very much, sir.
Professor Rajkumar, Professor and former Ambassador Rajamony, person who I consider a dear friend now, Ankit, and other young colleagues on the dais. It's always I always find it a great opportunity to share ideas when I speak on the Jhadav case. It has so many different dimensions for us as Indians. It has dimensions of foreign policy. And in fact, Professor Rajamony is more competent to comment than I am on that dimension. It has dimensions of the court as an institution, that every court is an institution. And how the court functions under pressures of the geopolitics, the hard reality of geopolitics. It has dimensions of evolution of law and the growing influence of human rights and the strong influence of human rights in the area of diplomatic relations. A growing understanding that there are certain basic principles which civilized countries must live by, and there are certain standards to which civilized countries must adhere. And they are at a level above and beyond national law and domestic law. And then, of course, there are the 3 or 4 important legal propositions which the judgment of the court deal with. And then there are the 2 or 3 judgments of which the judgment of Judge Concado Trinidad and Judge Robinson are my 2 favorites, because they picked up the points which were close to my heart, which I thought was a leap of faith. And I'm happy to know that certain colleagues with whom I discussed the matter said I was being perhaps almost naive, being not that experienced in the ICJ by arguing these points. I'm happy to see they found resonance in the judgments of at least 2 or 3 judges. The background to this case is very interesting. India and Pakistan have never agreed to the jurisdiction of the International Court of Justice generally. We have a carve out in what is called the compulsory jurisdiction in relation to disputes between Commonwealth countries. The word Commonwealth itself has now become an anachronism. There is hardly anything in common, at least between some of these countries and us. If we look around us, we are the island of democracy. If you look on one side, you see Burma. Sri Lanka struggles with democracy. And if you look above us, the picture is horrific. To our western side. It's India and now Bangladesh, which are the two islands of democracy. But yet we have this Commonwealth exclusion. And this stems from a general reluctance in India and a distrust in India over allowing any Western institution to intervene in whatever way in India's diplomatic relations. We have problems with Pakistan at multiple levels, be it the military, be it the police, be it borders, be it trade. And we have always stayed away from international institutions resolving any disputes between Pakistan and us. The only exception was the overflights case, which was under the treaty relating to sharing airspace. This was, I think, the second time India found itself in the International Court of Justice. There was a general reluctance, therefore, to move from bilateralism. And I must say, to the credit of late Sushma ji, who was the Minister of External Affairs and the Prime Minister, who immediately saw that we had an opportunity of saving one Indian life and put in the scales. They thought that outweighed any concerns, and there were concerns expressed by those in the diplomatic world saying, why are you doing this? And they said, even if he can get reprieve in which maybe through back channels, we can save this man's life. One human life is important. And it's that value system which inspired me to go and do my best. I remember when we started working on this, and when we obtained the first provisional measure, I think it was 2017 May, and I got a call from Sushma ji. We did all the drafting, and on a lighter vein, as you know, in India, and between India and Pakistan, we have, as I always say, spy versus spy. You know, we know what they are doing, they know what we are doing. let there be no mistake. So we had to be careful. I had to make sure I did all the drafting myself, saved it on a pen drive. That pen drive went to my junior, one junior working on it, circulated. That was given to the then secretary who was dealing with it. He would look at it on his pen drive, give it back to me, and that's how we managed to do it. It was all printed out in Blackstone Chambers in London so that there is no leakage, and it was filed. And to my surprise, Sushma ji called me and said, why aren't you going to Netherlands? And I said, it's to be filed. She said, I don't care. You go. I said, okay. So I went to do filing work for the first time in my life, and just as well, because I didn't realize before the registrar of the court, we had a very warm hearing in the sense he started asking questions as to what was the urgency. And I was happy to be there because I thought I could explain to him the enormity of the problem. And I must say, to the credit of the institution, the way they worked, they asked Pakistan if they would hold their hands. They didn't get an unequivocal reply. They put the provisional measures in place. That at least saved Jhadav from certain execution. We then hoped we'd be able to resolve this matter bilaterally, but it didn't move. We researched why I advised the government to try and resolve it if possible, is that this area was occupied by two earlier judgments, commonly known as the Avena case and the Legrand case. In both those cases, while the ICJ came to the conclusion that there was a breach of the Vienna Protocol, the ultimate relief they gave was not of any substance. The relief of review and reconsideration almost seemed a Pyrrhic victory for the winning state. And the Avena case has an interesting follow-up history. When they said review and reconsideration, the matter went back to the state court, who said there is no provision for review and reconsideration. So the matter was taken up at the US government level, and the president's office issued a directive to comply with the judgment. So that's what they could do. And the federal government in the US could not legislate on this because it's a state subject. And that was challenged in the US Supreme Court. And the US Supreme Court declared that law to be an unconstitutional interference by the president in the state. So the Avena judgment came to one big zero. And the Legrand judgment had no better fate. Now, the two important things about the Avena and the Legrand case, so they were not in the kind of circumstances in which we moved the court. Avena was about certain nationals who were arrested in the US for serious crime, put to trial, convicted, and then somebody realized that they were Mexican nationals. And America said, look, if you had known at that time, you would have given them consular access. I mean, America has no problem and no hesitation giving consular access. Nothing would have turned on it. They got full legal aid and they fought their case and they were convicted. Legrand, also the same thing happened. They were what looked like ordinary Americans. They were caught in serious crime. They were convicted. And it turned out, lo and behold, they were German citizens. So again, there was a breach, and America said inadvertent breach. I mean, sorry, we didn't know at the material time that they were Germans. Despite which the court said, well, no, this is a consular obligation, you have to fulfill it. And it found fault with America. You had America on the other side. You had a legal system which is trusted, tested on due process by the US Supreme Court and found to be fitting. So America said, okay, even if we have violated this, you leave it to us and we will sort it out. And they said, yes, we have faith in the American legal system. Now, those were the two judgments which we were faced with. We had to think of how to fashion the remedy. So we fashioned our remedy, and that is important because that has really what I feel been the first step in maybe a journey which the institution may have to undertake. We put 2 points in the scales: military trials and how far are military trials adherent or compliant with minimum due process standards. Because it was our submission that minimum due process is today a part of settled principles of public international law. Erga omnes, minimum due process. And we said by whatever standard you apply, a military trial doesn't fulfill that standard. And there was a lot of literature of international organizations which have over and over condemned military trials. And we put evidence before them of I think it was the European Commission of Jurists, which said somebody had done research on the death penalty is awarded in Pakistan, and they found 95% of the cases, they were in confessions. Now, to an Indian lawyer, I found it baffling that the allegations made by Pakistan was that in his confession, which was as vague as assuming he did confess and was not given an injection pursuant to which he confessed, or a gun on his head. It was one, if you see the YouTube video, it is one rambling narrative of how he has generally indulged in espionage activities on behalf of India. Not one incident is clearly spelled out. A confession would normally, to be admitted to a criminal court, have to state details: where he went, who he met, what exactly he did, who were the persons involved in the actual commission. Nobody suggested he planted the bomb. Now, if he were the mastermind's confession must say who he contacted and how he gave effect to his evil intentions. Not a word. Secondly, if there is a spy who has committed 6 or 7 different incidents of espionage and terrorism, there have to be 6 or 7 trials. You don't try a person, we try a crime. That's and Pakistan is the old CRPC in place. We have the same law. Our new CRPC is only a revised version of the old CRPC, in which one of the cardinal principles was you try a crime, you don't try a person. That's why in an FIR, you don't need to name anybody. You need to name the crime. Whereas this was a trial of a person for multiple crimes. And to date, we are in 2021. The charge sheet against him hasn't seen the light of day. It's literally a military secret in Pakistan as to what the charges against him are. So it was in these circumstances that we filed. Pakistan, of course, true to their ilk, first tried milking the situation. I remember when we went for the interim reliefs, they sought liberty to play a video. And they wanted to play a video of his confession. And they got a snub from the registrar, who gently but politely told them, please don't use this court for propaganda. So their video was shut out. In fact, Ambassador, morning we used to get applications saying we want so-and-so to be produced for cross-examination, we want so-and-so to be produced, we want to show this, we want to show that. And every morning at least 2 or 3 applications would get rejected when the main case went on. But they thought they would do that. Pakistan ran into very interesting cases. One is, they said, here is a passport which we have seized from him. How they seized from him, we don't know, which gives a false name. And therefore, India has equipped him for espionage. And we said, how is that relevant to consular access? First of all, has he been convicted for an offense under the Passport Act for possessing 2 passports? If he had an Indian passport, would you have acquitted him? If he had, suppose he didn't have a second passport, would you not have charged him with espionage? Right? What's the relevance other than theater? The second interesting case they ran is, the 2 limbs of the case was, do not allow him, we did not allow him consular access because here was a Navy commander from India indulging in espionage. The second case they ran was, India has not established he's an Indian citizen. So one limb was, he is an Indian Navy commander. It doesn't require great knowledge of Indian law to know that in no country can there be a Navy commander who's a citizen of some other country. So if he is the Navy commander and if he is in the employ of the government of India, and then you say you haven't established he's an Indian citizen, not, of course, to put too fine a point on it, that in a dozen communications which we received from them, the note verbals, they used to call him your citizen, your Navy commander. With all this, I think there are 4 or 5 important legal principles which came out of the attempts by Pakistan to try and find a defense to an indefensible case. My biggest concern was if Pakistan had come on day 1 and said, sorry, made a mistake, we will now do it. We will now give consular access and we will try him once again. The matter would have been over. And I don't think there's much we could have done about it. But I think God was on our side. They chose to take an obdurate position saying, first of all, they said India is guilty of abuse of process. Why is India guilty of abuse of process? Because you obtained provisional measures without exploring other mediation procedures. Now, come on, those are judges who know what's going on in the real world. Mediation procedures with Pakistan, who refused to give an assurance to the president of the ICJ that they would not execute a person in relation to whom a petition has been filed. The second thing, and that's a very important thing to remember, which comes out of this judgment, they put it in two different ways. India, they said, has come with unclean hands because India itself is guilty of violation of international law because of the various incidents in Pakistan. Now, apart from there being no proof for any of this nonsensical pleading, the ICJ clearly said, we have the Vienna Convention on Consular Relations, and we are concerned with complying with that convention. So this tit for tat argument is not a principle which civilized countries will accept. Retribution is not a defense in public international law. The International Court of Justice was created to prevent countries from taking law in their own hands. So that argument found its grave, and I'm happy it was firmly put down. The second important thing which Pakistan ran, and that is a very important point which they decided, is the consular relations principle cannot apply to spies. And that's a very dangerous principle. Let's be very clear. In normal cases, governments have no problem in complying with any of such obligations. It's only in the sensitive cases that these issues come up. What does it take for a government which is of the persuasion to disregard international obligations, to make allegations of spying? But let's be clear, this is at the stage when a person is arrested. This is not post-conviction. So you're at a very initial stage where the first flush of allegations is being made. Now, if you say, if I allege espionage, for which I may later apologize, consular relations go out of the window, you might as well pack up this convention and send it home. And that is why that was rejected. Of course, the interesting part of the lawyer I found is Pakistan must have spent some serious amount of money getting expert opinions and getting a lot of material, the Trawa Prapatoirs. We didn't bother looking at them because we were arguing on the principle of plain construction. They got all the Trawa Prapatoirs, which really helped us, because the issue of espionage was expressly raised. It was discussed. The people drafting the treaty said, we cannot have a blanket exception. Then they said, what do we do? But in some cases, if you arrest a person on spying, if you immediately tell his home country, they will be alerted. So if suppose you want to bust a spy ring, the whole purpose will be defeated. And this whole thing was discussed when the treaty was being drafted. And that's why from informing immediately, it became informing without delay. So they say if you need a few days to do your initial investigation, you have that elbow room in the treaty. So we thank Pakistan for giving all this material readily to us so that we could tell the court that please don't bother about this exception, because in fact, those who drafted it discussed it and said, no, we cannot have any such exception. The other important principle was that the non-signing of the Vienna Convention on the Law of Treaties doesn't matter. Treaties will still, because what does the Vienna Convention on Law of Treaties say? Good faith and plain language. And they applied the principle of good faith and plain language in interpreting the Vienna Convention. The next important principle, which I find strengthened the convention, is Pakistan said the détenu must request consular access. Now, there again, if they accept that principle, it's very easy for a state to deny consular access and say, oh, but we were never requested. And it's the word of the détenu versus the word of the state. So the ICJ said, no, you have to offer it to him and you have to establish that you have offered it to him. Then if he refuses it, it's another matter. And then the second principle, that the consular access is not just the right of the détenu, but also the right of his home state. Their right to meet their own citizen. So that is an important dilution of the Vienna Convention on Consular Relations, which was rejected by the court. The next important dilution, which they rejected, was that in any case, the consular access has to be as provided for in domestic law. Now, run to its logical consequence, it would mean that if by domestic law you take away consular access, the treaty is written on water. Unsurprisingly, this deeply unattractive submission was rejected. The other important point which Pakistan ran, and this is interesting, when the investigation started, and everybody knows Pakistan is under heat to cooperate with India to investigate the Bombay terror attack. So Pakistan, after this, gave a long list of people they wanted to interrogate, who had been, according to them, named by Mr. Jhadav, Home Minister, Head of Information, Head of the IB, Head of the CBI, etc., down the list from the senior-most functionaries in India. They said, you must make them available for an investigation by Pakistan police. India obviously treated that request with the contempt it deserves. Pakistan argued India, by refusing to cooperate, is in breach of its international obligations and therefore should not be allowed to complain of the violation of the Vienna Convention. Even this argument was rejected, shorn of the diplomatic language of the judgment. I read the judgment as saying, don't make prisoners political pawns. You may have your differences with countries. Don't extend them to crush rights of detainees. Then came the problem about, so breach was easy. Question is remedy. The judgment of the court, not the separate opinion, but the judgment of the court, has taken Avena and Legrand forward. First of all, they had the dead weight of these two judgments sitting there, review and reconsideration, as against which they had the problem, which we told them, and my submission was, they were because the fairness of the American system was not moot in that case. In our case, the fairness of the Pakistani system is moot. What do you want to do? Send him back to a military tribunal? And will that be a relief that an ICJ will ever give? Stuck with this argument, and we brought into play the ICCPR, a fair trial. The Covenant on Civil and Political Rights shows us a fair trial. The full judgment, that's something interesting. It says, since our jurisdiction is so limited, they're not happy that India is a carve-out. Otherwise, a lot more work. I think every third day there'd be cases between India and Pakistan before ICJ. So what they said is our jurisdiction is limited to the protocol attached to the Vienna Convention on Consular Relations, and therefore only disputes regarding the interpretation of that treaty can come to us. But they said in interpreting the Vienna Convention on Consular Relations, we will keep in mind the ICCPR. The seed has been sown. The second important change is while they did not reject bag and baggage, the Pakistani system of military trials and did not discuss it. What they did do is they ran through Pakistan's arguments of what would happen and virtually said, you will go back to the military court, not good enough. Your clemency, not good enough. Judicial review on narrow grounds, not good enough. You must provide for effective review and reconsideration. Para 139 says, must be effective. It is a result of an obligation. The Para 145 says, fair trial is imperative. If they had accepted the Pakistan view that the military trial is a fair trial, there was no occasion to say this. And they close by saying the relief and reconsideration must take into account two things: the implications for the defense of the breach and the implications for the evidence. Now, one of our submissions was, if the linchpin of this case is his confession, and that was recorded in breach of the Vienna Convention, then you have to put that so-called confession to one side, give him full consular access, and then see whether he still confesses. Now, if that happens, this conviction is toast. And that is where Pakistan is stuck. They said you must take all measures, if necessary, by enacting legislation. Means what you have told us so far is not good enough. And what has Pakistan done? They have made a law saying a petition will lie to the court for effective review and reconsideration. What does that mean? What does that mean? Judicial review. Can you argue before the Pakistan court, because they have the same principles of JR as we do? Can you argue before that? That because of want of consular access, the confession is illegal. You can't. You're mixing up two legal systems. One is municipal law, the other is public international law. They had to create a system in which somebody could resolve this issue. And I'm not going to re-argue before a Pakistan court on whether or not the Vienna Convention was violated. It was. So if there has to be an effective review and reconsideration, what you have to have is a system which is empowered to put all this to one side and put him on trial with full assistance from India. Do we have that? No. So Pakistan is continuing the shadow box. And we've had these exchanges going on. And they say India must appear. And we say, India, why will India appear in a Pakistani court? That's not what the ICJ obliges us to do. So this sort of thing is going on. And I hope someday Pakistan sees the light and fixes this. Otherwise, who knows? We may be back in Den Haag. The separate opinions go the whole mile. They bring in human rights jurisprudence into public international law. These separate opinions serve a great purpose. It showed that while everybody was aligned on what all the judges held, some of them felt that the court was not going far enough. In fact, for example, just Trinidad says, we have not gone far enough. The majority doesn't go far enough. And he says, Avina and Legrand, you have to move beyond that. The seeds have been sown. And maybe around this convention, we will evolve into jurisprudence. Maybe when we go back, if Pakistan doesn't comply and we go back, we may have to take things further on how to comply with the judgment. The only unattractive bit is I will not get the lovely dinners I used to get from Mr. Rajamony's home, which kept me going because I was there for 2 weeks nonstop. I did the Vodafone arbitration with this back to back. And I wouldn't have survived those 2 weeks if it wasn't for Ambassador Rajamony's hospitality. So this is what this judgment is about. It is very significant in all these ways. It is very significant because India today was bold enough to take this measure, to take Pakistan to court, to get this judgment. And I believe this had resonance in the United Nations, in the address which the president of the ICJ gave to the UN General Assembly, where he mentioned this was one of the important judgments of the ICJ. Why is Pakistan not complying with it? Well, that's more a political question, but I was somewhat surprised when Pakistan said they had won the case. I thought maybe I had misheard the judgment. Maybe did I hear dismissed instead of allowed, or allowed instead of dismissed? Did I miss some knots, NOTs in some of the readings because the judgment was read in court? Having built up this whole we won the case theory, it's now becoming very difficult because if they release this man, people will say, what happened if you won the case? Why are you releasing this man? Now that's a political impasse they have created, they have to resolve. For us, we have established that we are now unafraid of international institutions. We are parties to certain conventions. We will assert our right. We will go forth. We have our own jurisprudence. We have people within India who understand our jurisprudence. And we will go and fight and we will win. And I think that message is what had such an effect on the Indian emotional psyche that for one single man, India was willing to risk everything. We were willing to risk things going wrong. We were willing to step out of our comfort zone of bilateralism, step onto the world arena, world stage, and wrestle with Pakistan. We came out successful. We have established that one Indian life is worth more than the misgivings of the doomsdayers. And this is a new India you have to learn to live with. Thank you.
Thank you very much, Mr. Salve, for that very erudite and at the same time interesting lecture, which touches on various aspects of the case. And your conclusion is particularly poignant where you talk about the arrival of a new India, which is no longer afraid of international institutions, which is brave enough to go into, step out of the bilateral arena and wrestle with Pakistan, if necessary, in the international arena. So I was just wondering whether you could share a little more of your thoughts on what next from now. How long do we wait? What would we want Pakistan to do, other than, of course, we would love to see him released and sent back to India. But where do we go from here now?
Yes. So there has been back and forth between the two governments. We all know what is going on in Pakistan. To expect bold political moves in this area today appears to be almost unreasonable, because they are victims of their own politics, and having built up this huge edifice of lies, of trying to create a narrative. The day they arrested him, we were informed 5 days later, but that very evening of his arrest, a press communique was sent out to the Middle Eastern and the Islamic countries saying, see, we told you India is responsible for all the problems of Pakistan, and we have arrested a man, etc., etc. So Pakistan has been using Pakistan military, which had not covered itself with glory, stands badly exposed. In the world, they thought they would hit back at India. This has come back to bite them. Now, quite frankly, they are between the proverbial rock and the hard place. They don't know where to go with this. Speaking for myself, I have always been, at a very young age, my father presented me with 4 volumes of William, written by Winston Churchill on World War II. And I remember on the cover, it said, in victory, magnanimity, in defeat, defiance. I have no problem in India in a bilateral resolution, bringing Jhadav back through what popularly is called the diplomatic back channel efforts. We did this not to shame anybody. We did this not to humiliate Pakistan. We did this to save an Indian life. And honestly, I don't care how we save it. Having said that, if Pakistan still does not come around to a final resolution, we may really have no choice but to go back to the ICJ and say, we have tried our best, nothing seems to work. But sometimes the threat of action can be more persuasive than the action itself.
Salve, we have been getting some questions from our viewers. So one of the questions is, what would you, if you had an opportunity to advise or to advocate, how do you think the ICJ should expand this business of linking human rights or bringing more human rights? ICJ not being only about states, but also individuals and their rights.
See, access to ICJ by individuals would be a bit of a leap of faith. Not that I think there's anything wrong in it, but maybe we need to create an institution, a transnational institution for human rights. Countries would be very uneasy. In fact, look at, I think it was the Legrand case. America walked out of the case. They challenged jurisdiction. When that failed, they walked out of the case. So countries don't like being supervised by an international institution. So if the ICJ has been following this policy of what one may call hasten slowly, step by step, may be a good idea. If in the first instance, we get an infusion of human rights, if the diplomatic principles and public international law is imbued with principles of human rights and ICCPR and things like that, we might be able to make the ICJ an institution where things such as political arrests, these kind of kidnappings and detentions at the international scale, violating territorial sovereignty by sending raiders, as is happening in a lot of parts of the world, and destroying peaceful existence and property, throwing fishermen in jail. All these, if once it gets to the human rights overlay takes hold, I think the jurisprudence of the International Court of Justice would be a lot more richer.
Ankit, you had a question to ask?
Yes, thank you so much, Mr. Salve. It's been a treat to listen to you. I must come in full disclosure. I am studying Professor Rajamony's course, and I have been put in the precarious situation of defending the Pakistani situation or the Pakistani viewpoint in a moot court situation. Now I'm heavily arguing that Professor Rajamony might not be a judge in his own cause, but but my question stems from reading and trying to prepare a position which gets completely decimated by reading what Judge Iwasawa talks about. What Judge Iwasawa speaks is that even in these conventions which deal specifically with different types of terrorism, there are safeguards provided. And one safeguard which he highlights in his opinion is that of fair trial, which is at the essence and the core of this dispute. So, I mean, then the Pakistani situation seems rather retarded and inconsequential in all aspects and regards.
One of the areas which I wish, frankly, they had taken the gauntlet. Pakistan filed, strangely, Pakistan filed expert evidence on how military trials are perfectly good. And they tried to internationalize the issue. Maybe the ICJ could have picked on that and come down heavily against military trials. So that was a missed opportunity, where at least 4 of the judges have echoed it, saying, fair trial today is axiomatic. It's a value system with which human beings can't live with. I mean, on a lighter vein, I was watching something on Netflix that day about, there is a serial going on 9th century Britain, the fights between the Danes and the Saxons. And at one point, a person who the king is hearing, and he's accused of treason. And something happens, and the priest shouts, "You must give him a fair hearing. Justice must not only be done, it must be seen to be done." Come on, this is the 9th century. We are now in the 21st century. Surely we need to be much beyond what that priest said in the 9th century. And that has to become an axiom of international law, that a country which has military trials simply is below the standards. And the moment you inflict it on your own citizens is bad enough. If you subject foreign nationals to this treatment, you will be violating international law. I mean, we deal with Pakistani spies, right? We've dealt with terrorists, and we've shown the same CRPC can work with terrorism. So what's the need for all this military trial?
Absolutely. Thank you, Mr. Salve, once again for your remarks and for the wonderful victory that India achieved in the court, not just for India, but for human rights jurisprudence across the world, and the manner in which the case has become a precedent for the future. I would like to now invite one of our young colleagues, Professor Mercy Debra from the law school, to say a few words in conclusion.
Yeah, thank you, Professor Rajamony. A very good evening, good afternoon, and good morning to all of you who have joined us for this distinguished lecture from different time zones. It is indeed an honor and a rare opportunity for all of us to have Mr. Harish Salve deliver this lecture on this important case that has been one of the highlights of his career. So thank you so much, sir, for giving us such an illuminating and instructive lecture on the Kulbhushan Jhadav case. And each one of us, in fact, who've joined for this lecture have in some measure or the other been gripped by the travails of this man who's at the center of this maelstrom involving an acrimonious dispute between India and Pakistan. And these lectures that are hosted by our students and specifically by the Jindal Society on International Law are not just informative, but also a reminder that at the end of the day, we have these men and women who lie at the heart of such embittered battles and for whose freedoms we must continue to contest for even far after the spotlight on these cases occasionally wanes away. So on behalf of OP Jindal Global University, I just want to take this opportunity to once again express our gratitude to you for taking the time out to walk us through the trajectory of this case and also for giving us a first-hand account of the nature of arguments that were canvassed and the insights into the fault lines in this case that have made it indeed so difficult to secure a safe passage for Kulbhushan Jhadav to come back home to India. And the complexities that have been involved in this case have not just required on your part to set out a very valiant contest from your side as well as from India's side at the ICJ, but also it continues to be in many ways a stark reminder that the price of freedoms is often borne out of the sacrifices of men like Kulbhushan Jhadav. And so while legal and diplomatic struggles continue, let's hope that this contest that has been waged yields a desirable outcome through the effective and review and reconsideration of this case by the superior courts in Pakistan, as was mandated by the ICJ judgment in July 2019. So we also wish to thank all our distinguished guests as well as our audience who have joined us virtually from different time zones. And we hope that each one of you have benefited from this insightful lecture delivered by Mr. Salve. Thank you so much, sir, for taking the time out to deliver this lecture for our students, for the benefit of many students who have virtually joined us and who would continue to watch this lecture, which is available online. So thank you so much for joining us. And over to you, Ankit, to conclude the proceedings.
Let me add to that, and let me thank the Vice Chancellor for institutional support, Professor Srijit, who's not here right now, but he provided knowledge support to me while imagining and envisioning this lecture. But the most important piece of the puzzle was Professor Rajamony, who provided professional and diplomatic support to organize this, and Mr. Salve, of course, without whom this occasion would not have been possible. Whilst preparing for this lecture, I was told that I should read and reread the case and also see what Mr. Salve had to say. Now, my readings pointed me towards studying and understanding that the ICJ is not a mechanism which is as appropriate and helpful as a applause at the end of a second movement of a string quartet. It is rather, as Mr. Salve puts it, is the graver the charge, the larger need for justice. The international obligation must be followed, yet they are brazenly not followed. These are grievous crimes and violations of principles of international law and also human rights law. My professors, Professor Philippa Webb and Umal Clooney, have written an entire book on this chapter, which talks about the right of fair trial in international law. To this end, let me before I end, let me just add to what Article 14 of the ICCR talks about, and how this case has created what Professor Vaughan Lowe and others have spoken about in the context of creating a path, or creating a special footpath for international law, and how it furthers the erga omnes obligations towards states, as Professor Rajamony was discussing in his class. We are grateful to the Councils of India for this and for the developments, the progressive development of international law this judgment has brought about. And to that end, we are grateful to Mr. Salve, to Mr. Rajamony, and the entire team. Jai Hind, and thank you everyone for joining us on this memorable occasion.
I would only add, Ankit, if you are going to be defending Pakistan's position and an unenviable job in the moot, one thing you would do learn is what language not to use in the ICJ. Professor Rajamony will tell you more about that privately.
The brightest student has been given the toughest job.
Well, Thank you so much, everyone. It's
Thank
been an
you.
honor.
Thank you, Mr. Salve.
Thank you, Mr. Salve, once again,
Thank you.
and we look forward to
Thank you
receiving
so
you on
much.
campus in the near future,
My
whenever
pleasure.
you come to.
My
Thank
pleasure.
you.
I would
Thank
love
Thank
to
you.
come.
Have a great evening. Thank you for taking